Morning meeting of corrections and institutions for February 26th. We have with us attorney Ben Dobrowski to talk about two bills. One is H-176 and the other is H-219. And we will be getting our overviews, introductions to these. And Ben, please take it away.
Great. So for the record, Ben Dobrowski from the Office of Legislative Counsel. Before the committee is H-176, entitled An Act Relating to Developing the Department of Corrections Community Restitution Program. What you may remember from last year is, I believe it was in S-195, so I think that turned into Act 138. There was within the sentencing statutes, which is 13 VSA 7030, one of the sentencing alternatives that was added was the reinstitution of community restitution, which is commonly known as work crew, based on the policies implemented by the Department of Corrections. From my understanding, and I'm sure from prospective witness testimony, you'll learn that there is a bit of a, I think, tension between the department's chosen path and that between the prosecutors and the courts about how this program should operate. This is an attempt to address that issue. So what you'll see here is in section 1, and this is session law. So it's not going to go into the green books, but it mandates that on or before July 1st of this year, the Department of Corrections shall reinstitute the field-based community restitution program commonly referred to as work crew that was discontinued by the rescinding memorandum issued by the department, which rescinded Department Policy 339.01 and 392.01, which you should be available on the committee's website and may also have printed policies in front of you. So those department memos essentially outlined the operation of the old work crew program that were then rescinded, where I believe, I forget the exact number off the top of my head, but I've also attached the new memorandum issued by Commissioner Demel, and it appears like this. Mm-hmm. And so you have those for reference, but basically this would revert to the old system, and that the department under subsection B, department may enact policies limiting the numbers of days ordered on a single minimus. Now, minimus is essentially like a sheet issued by the court outlining sanctions and requirements. So just so you have an idea. So you on a single minimus, so a single court order, and how many total work crew days an offender may have outstanding at any time to be eligible for work crew. So it's saying we want you to adopt policies outlining exactly what the terms are for the days that an individual needs to serve in work crew. However, the department shall set the number of work crew days imposed under one minimus to not less than 20 days. So 20 days is the minimum. Or the total number that may be outstanding on multiple minimuses to not less than 60 days. So 60 days being the minimum. And this would go effect on passage. Now, this is probably sort of an abstract amorphous concept right? So I'm going to entertain any questions about what in the world any of this means.
What in the world?
No.
Are you okay?
No.
Let's go back and reason. Make sure we raise our hands, Kevin. No, Kevin had a question.
No.
Joe?
What defines a day?
A single day.
It's like 2 hours, 5 hours. Any period of time in any calendar day.
So they have to show up at a certain amount of time. So work crew in its old form was really, from my understanding, and I would defer to the department as, more in the know exactly on the inner workings of this, was really like community service in the sense of you know, you would see work crews along the side of a road picking up trash and things like that. Mowing lawns, maintenance work, things of that nature. And so there was a lot of equipment required. And my understanding from the department is that they ended up running a deficit for the program because they had troubles with no-shows. And a lot of the requirements, I think some department employees actually ended up having to complete. The newer version, from my understanding, is more, is not so limited in scope. So the community service that can be done can be, I think, things along the lines of assisting in soup kitchens and things like that. So a little bit less labor intensive work. So that's the concept of what the differences are between the two programs. And right now it seems like, since the statute under 7030 gave the Commissioner of Corrections sort of unfettered ability to create the program and how it operates, I think that's why you're seeing this bill, is because it puts some guardrails on how it were to operate and the mechanics of it.
So I have a quick clarifying question, then comment. Joy. So with Joe's point about days. So is there anything anywhere that says the day is 6 hours or 8 hours or 10 hours, or is it just vague?
So my and again, I would defer to the department to get more information, but my understanding is that there are contracts and they can set the terms and conditions of what attendance looks like based on the minimus.
Okay.
So I think all of that can be worked out.
All right.
So Ben, is there anything in statute is there sort of an or else what provision if somebody doesn't show up? It's totally discretionary with the
Yeah, right.
judge?
Well, right now, it's not even discretionary with the judge. It's discretionary to the commissioner.
Okay. And we can ask the commissioner maybe how that actually works in practice.
Right, because if you were to look up 13 VSA 7030, it just, almost a direct quote is, you know, can sentence someone to community restitution, as determined by the policies of the commissioners or something to that effect. So it gives that legislative kind of discretion to the department to create the program as it sees fit.
Interesting. Yeah, thanks.
Troy?
You mentioned that this might tweak what's considered appropriate labor. Do you know where I can find that information?
When you say, well, so so just to clarify, so the new DOC program is more expansive scope of what can constitute.
Right, so where is that?
Well, I do know that there's this initial memo, but that was from conversations with the department, so I would ask them.
Okay, thank you.
We get a lot of questions for DOC already. Inside. Are there other questions specific or help to understand? And if not, who we should have a conversation about who we should have come to testify? Obviously DOC, but who else should we ask to come testify about this?
I would recommend the Department of State's attorneys and sheriffs, since the prosecutors are the ones that may be consenting or stipulating to such a sentence. The judiciary as well, so Chief Judge Zone and or Court Administrator Corsones, since they're issuing the minimuses.
Yeah.
You may also want to get the Defender General and their perspective, so they may be, because they're representing many of these individuals.
Okay.
2 of those 4 are scheduled tomorrow afternoon at 4.
Okay.
Off the top of my head, that's, I think, a good starting point.
Okay. Brian?
Basic remedial question that just popped into my head. These folks who are on work crew are not staying in a facility after they're done, right? They're on home arrest and coming to do the work.
Well, so this is right. I mean, my understanding is that they're in the community.
Yeah.
And so they, you know, but the requirement of their sentence
Yeah.
is that they appear at X day and time to do X work.
Cool.
Yeah.
I was just trying to make the money work in my head. Okay. Yep.
So if I'm hearing you correctly, so really is kind of like the person's got community service. At least this is what kind of looks like.
Yeah.
Or,
A good way to think of it is, and it's literally listed as an alternative sentence in statute.
okay.
So alternative to incarceration.
Any other on this particular?
Just one clarifying point. As Ben said in the memo that we have on our website, it does say for what would be a 14 to 15-day sentence, do this many hours of community service. So there's an equation telling you
Okay, there
what you got to do.
And then, so I think we're good on this one. I mean, everybody, what the feeling of taking this up? The answer is we are taking it. So we'll do this anyway. Is everybody cool with taking this bill up? Troy says no.
Well, you just got things you want to put in there, right?
So put your thumb, give me a thumbs up if you are fine with taking this bill up.
Yeah, I'm correct.
Okay, so that's the end of that subject. I understand where you're coming from, Troy. All right, so Ben, we'll move on to the next,
All right,
which is
19.
19.
just give me a minute to switch gears.
Thank you, sir. Troy, I bet you like this one.
Did you send me any
You're on
documents on two?
That's fine for this one.
But I didn't do any other.
I'm going to refer
Just like
to Representative Edward as my document. Phil asked me if I had any documents with 219 and I referred to you as my documents.
Bring a legislator to work day.
Exactly.
19 is an act relating to creating a family support pilot program for incarcerated parents and guardians.
Exactly. Yeah. So I will share my screen now. Okay, so yes, again, for the record, Ben Novogroski from the Office of Legislative Counsel for the committee's H219. And as Vice Chair Gregoire just said, it's an act relating to creating a family support pilot program for incarcerated parents and guardians. And this is based off of the Lund Kids Apart program, which, and I'm going to defer to Representative Hedrick a little bit to give some more background, but essentially right now that is operating in the Chittenden County Regional Correctional Facility. So the women's facility to essentially facilitate family-friendly visitation for incarcerated folks. Last year in S-195?
Yeah, it was our.
Yeah, there was essentially a working group created to discuss expanding this program to all facilities and specifically anyone who has a, parental or custodial relationship.
No, that came out about a year.
What's that, Troy?
Just trying to remember the bill number where that came.
Oh, it may have been H7. It was the miscellaneous bill.
Yeah, it was a
Yeah. And so, or H36, I believe. And so that was a working group that was established to expand that program. And I think this is essentially the next iteration of that, where this sort of contract-based program, because right now it's DOC contracts with Lund, provides a grant to them to establish these family-friendly visitation policies. This would create a statutory requirement to do that with attendant funding. And so getting into section 1 of the bill are the findings and intent supporting the bill. So the General Assembly finds that approximately 6,000 children in Vermont have an incarcerated parent or guardian annually, with a significant majority unable to maintain meaningful family connections due to a lack of correctional facility programming. Research demonstrates that comprehensive family programs, including opportunities for child-friendly visitation, assist with reducing recidivism, enhancing community reintegration, and promoting child well-being. The Department of Corrections collaborates with a local nonprofit to provide incarcerated female parents and guardians at the Chittenden Regional Correctional Center with a trauma-informed, comprehensive approach to strengthen family connections that minimizes the adverse effects of parental incarceration and fosters better outcomes for parents and children. While Vermont incarcerates a higher percentage of parents and guardians compared to the national average, and provides family-friendly support services for incarcerated female parents and guardians, no comparable program exists for males, which leaves a critical gap in family support services. expanding family support services and programming to incarcerated male parents and guardians may yield social benefits by preserving family connections and mitigating the trauma of incarceration on parents, guardians, and children alike. Moving to subsection B, which is the intent, is that it's the intent of the General Assembly that the Department of Corrections ensures gender parity and access to services and programs that strengthen family connections. And it's the further intent that the Department of Corrections develop a phase plan to expand the application of 28 VSA Section 128 to all Vermont correctional facilities by 2028. 28 VSA Section 128 is proposed to be added in this bill as the program. So any questions about the findings and intent before we get into the technical parts of the bill? Yeah. Moving to section 2. So section 2 amends 28 VSA 102C, which discusses the Commissioner of Corrections duties and responsibilities. And this amends the responsibilities by adding a new subdivision 24, which requires the Commissioner to include funding to sufficiently provide and sustain trauma-informed family services and programming pursuant to section 128 of this title in the department's annual proposed budget for the next subsequent fiscal year for the purposes of developing the state budget required to be submitted to the General Assembly in accordance with 32 VSA 306. That's a really wordy way of saying the departments recommend that is rolled into the governor's proposed budget. You need to include sufficient funding for this program. That's what it does. Section 3 is the substantive part of the bill, which adds the program itself. So it creates section 128, Department of Corrections, Incarcerated Parents and Guardians Family Support Pilot Program. Subsection A describes the program to say that it shall establish pilot programs at both Chittenden Regional and Northern State Correctional Facility to provide free parenting and family support to all incarcerated individuals who are parents and guardians. The program shall include the following services and programming. To provide increased knowledge and skill for incarcerated parents and guardians to address the specific needs of their children, to provide enhanced capacity and resources to those parents and guardians to help engage in need-specific planning and communication strategies with their children and children's caregivers, to provide child-friendly visitation spaces for in-person and virtual visits between parents and guardians and their children, including establishing safety protocol, to provide outreach and coordination with appropriate services for the children of incarcerated parents and guardians and the caregivers of their children, and to provide reentry support and preparation for incarcerated parents and guardians, and to provide improved cross-system coordination and collaboration to deliver necessary services to the families of incarcerated parents and guardians. Subsection B establishes the program support so that the department may support the operation of the programs either through grants of financial assistance to or contracts for services with any nonprofit entity that meets the department's requirements. Presumably, Lund could be one of those entities, but it is not specific to that. Subsection C creates an annual report requirement that every year before July 1st, the department submits a written report to this committee, the House Committee on Judiciary, and then the Senate equivalent committees concerning the funding, participation, and outcomes of the services and programming established in this section, and considerations and any progress towards statewide implementation and gender parity. And then finally, section 4 is an appropriation of $400,000 from the general fund to DOC in fiscal year 2026 for the purpose of establishing and supporting this program.
So if everybody remembers our letter yesterday, we had put in money for support for this. But also, just before I turn it over to Connor for his question, for anybody who doesn't know, at 1 o'clock today, we have the DOC, Lund, Kids Apart, and Parent Child Centers coming in to talk about this. They won't get to in detail because it's only an hour, but it'll be a good start on that. So, Connor.
Yeah, sort of a Schoolhouse Rock question, Ben. What if this bill passed in its entirety, right? But that money isn't reflected in the approach bill for the 400,000. Does that like sort of nullify the rest of the bill because they don't have the funds to do it then, or do they have to eat that and find it somewhere else in their budget?
I think it would depend on the current state of the budget, which I'm not currently aware of.
It's a good deal.
But my understanding is that previously, this amount was funded, through like, I think the grants line item in the budget. Whether or not that's present now, and if it is not present and there's $400,000, then I think that would be an implementation problem. What we did, there are ways to do that. That basically says if the program is not funded, it doesn't operate. So you can kind of make it contingent on receiving those funds. So you're not essentially establishing a mandate that can't be met. But we can get there. We can
Yeah.
cross that bridge if we get there.
Right, thanks, Brent.
Other questions?
Yeah. I think you said this towards the beginning of your presentation, Ben, but the program at the CRCF already exists. And so this establishing a pilot program, this is just a way of codifying it, putting it in statute.
Exactly.
Okay, thanks.
Yep.
And
No, that's not the answer to the question.
okay, then as we talked about the other day, I mean, I don't think anybody in here doesn't know this, that this is, to get it started, to see how it works in the men's facility. But the long-term costs would be much more significant. Not, I actually support this. So the way, I will say that when I'm saying this thing is going to cost money, but it will cost more money than the 400,000 because it will be in other facilities down the road. But this is just to get parity so that the men have the same option, or more importantly, the children of the men have the capacity to do what's already happening in the women's facility. So, other questions? Or yes, so
Well, just to briefly finish, section 5 would repeal this program by July 1st, 2028. So that gives the legislature time to assess it. Essentially, if they want to make it statewide, if they want to keep it as a pilot, or if they just wanted to let it sunset altogether.
okay.
And then the act goes into effect on July 1st of this year.
And I assume everybody knows this, but just so that what that means is if we want this program, we have to come back and revisit it or it dies. So it's not one of those programs that we're creating and then we have to go back and go, no, this isn't working, and we have to do new legislation to get rid of it. That's built in that says if this doesn't work, and we just can just wash our hands and walk away. Kevin?
I too generally support what I understand. I don't see in here anything to the effect of how do we measure that the program is effective or not.
So there's that annual report requirement in subsection C of proposed section 128 that would provide information on the funding, participation, and outcomes of the services and programming.
Okay, so
And then any considerations in progress towards statewide implementation.
so it's there, but it's very general.
And then just a note on the funding piece. So the way that this bill is structured and also the constitutional limitations of our government is that a current legislature cannot bind future legislatures to spend money. So what this essentially does, though, is it says this year, $400,000, but that amendment to section 102 of the commissioner's responsibilities essentially says this has to be part of your base funding. But we can't tell you what that amount is. But whatever is determined to be sufficient, you got to roll it in.
Yep.
So that's sort of the mechanics of how that works together.
On Kevin's question, which I think is probably bigger than for here, but what success looks like? How do you even measure that? I mean, it's not really a question for you. It's just something that when Kevin mentioned it, makes me think like what you don't really know. We have feelings and thoughts, but so any other questions? Yeah, Brian. Yeah.
Sorry, Brian, you can't ask me anymore.
Yeah, actually, I do have to ask on the floor after a while, don't I? Yeah, shut them up. The money that the commissioner has to find in the base budget is only for the pilot programs or is for all the facilities ultimately?
Right now, just
Until
for,
28.
yeah,
Okay.
just for the pilot,
Cool.
unless the legislature decides to change
Yep.
that.
But that makes me think. So Ben or Troy, since you wrote the bill, or it's your idea, but you wrote the bill. So this is for the pilot. And nothing happens until we come back to there's no the pilot's successful and they just start rolling with it and expanding it. They have to come back here before they can expand it. right? Or no?
This just creates a pilot.
yeah,
That's all
I mean,
this
if they want to, there's nothing that restricts them from expanding it on their own.
But they're not required
They're
to,
not required to.
and they can, then just come back to us and say, we want this money and you can, say, okay, I got it, I'm on the same page. Anything else? And remember, so this afternoon, like I said, it's gonna be, I mean, with 4 or 5 people testifying, that's not gonna take, you're not gonna get too in depth. But think of questions that we have for them and, you know, what this is gonna look like. I'm even not just the program or the pilot, but like, what's the goal long term, et cetera. But, I'm good if everybody else is good. And Ben, thank you very much for coming.
Sure.
Committee, I think that we will just be done. I have a meeting at 12, so this works out perfectly fine. Give me time to eat. Make sure you're back here at before, 1 o'clock and hopefully start on time. And Phil, we can go off live.
Just 1 sec.
What time are we taking up the letter? Is that at 1 or at 2?
One.
It's at 1, okay.
Oh, the letter? The letter is, no, the letter's.
The letter
It's at 2.
Yeah.
Okay.
Yeah.
I will see you all back.
Did you put this in there? Alice said that.
I did. I
Did
just,
you use up to?
We're still on live.
yes. Okay.